The prosecution is contending that it has the right to call witnesses to take the stand during the preliminary inquiry, while the defense is contending that since it is a paper committal, the prosecution should not be given the luxury of calling witnesses to the stand. The prosecution says it wants to call 15 witnesses, whereas the defense only wants to call one witness, but based on the evidence of that witness, it may call a second witness. Those were the contentions when the matter was called last week, and Magistrate Renita Singh was expected to make a ruling today. However, when the matter was called today, State Prosecutor Stacey Goodings pointed to Section 71A of the Criminal Law Act, saying that it explains the course by which evidence is to be taken and it gives the prosecution the right to call witnesses. Goodings noted that the defense has been using the very section to say that it should proceed by way of paper committal. This process, she noted, also gives the defense an opportunity to cross-examine witnesses. She also argued that the prosecution has disclosed fully to the court and to the defense all evidence that it has. However, Attorney-at-Law Sandeep Dattadin, in response, also referred to Section 6 of 71A and noted that the prosecution cannot cross-examine its own witnesses. He told the court that Sections 62 to 68 of the law were made in the 1950s and Section 71A is an amendment to those laws which was put into law in 2008. He later explained to reporters what the defense position is.
Which is that the statements of the witnesses are marked as exhibits, as it were, and that's how the deposition is created for any further trial that may take place if the magistrate is to find that a prima facie case has been made out. What they're trying to say is that the old procedures apply, but this amends those procedures, and it's mutatis mutandis, which means those provisions only apply now insofar as it's not inconsistent with Section 71.
During today's hearing, Dattadin said that the defense has accepted all of the evidence which the prosecution has indicated it has and only wants to cross-examine one or two witnesses. The defense is contending that it will take 1 day to conclude the preliminary inquiry if it is allowed only to call one or two witnesses, but it will take 45 trial days if evidence is to be taken from 15 witnesses. The accused, Marcus Bisram, Dattadin noted, does not need the luxury of hearing all of the evidence in court.
What has to happen is they have to mark the witness statements. The person has to be represented by an attorney-at-law. If he's unrepresented, it has to go the long way. The third thing is that the defense must indicate who are the persons they wish to cross-examine. So they only cross-examine those which they are. Remember, this is not a trial, this is an inquiry into whether or not there is evidence. The other thing that must happen is all the documents, all the tapes, all the pictures, anything that the prosecution would like to make a part of his case has to be produced to the court, and they also have to be marked.
Magistrate Renita Singh has set February 10 as the day she will make a ruling on the submissions. Both sides are to be ready to proceed depending on which way the ruling goes. For the Evening News, Andrew Carmichael.